Good morning and welcome to the Judicial Committee of the Privy Council. Today we're hearing an appeal from the Court of Appeal of the Cayman Islands in the matter Royal Cayman Islands Police Association and others against the Commissioner of the Royal Cayman Islands Police Service and another. The appeal is concerned with the question whether changes in the police retirement age cause discrimination against certain police officers contrary to the Constitution of the Cayman Islands. I'm Lord Briggs. Sitting with me today are Lady Arden.
Good morning.
Lord Kitchen.
Morning.
Lord Stevens.
Good morning.
And Lady Rose.
Good morning.
Counsel for the appellants are Geoffrey Jupp and James Rowbottom, and for the respondents David Perry, Queen's Counsel, Catherine Hardcastle, Reshma Sharma and Claire Allen. We will take a short break at a time of counsel's choosing, roughly at about 11:45, and I'll call on Mr. Jupp to begin his submissions.
My lords, my ladies, you're aware of the representation. I ought to add that our respective clients are no doubt watching on the live stream from the Cayman Islands, where it's about 4:30 in the morning. My lords, as well as the electronic file, there should be a supplemental bundle of 3 authorities which repeat certain authorities in the electronic file, but in a different format. Can I confirm that you have that?
Yes, thank you.
Thank you. My lords, my ladies, the appellant's case is set out at page 96 of the bundle, and we take that as read, and we rely on the arguments we set out in it. I will deal with the issues in the order that they are set out in the statement of facts and issues. First, the ambit issue, which will take up the bulk of my oral submissions, then the section 19 issue, and finally, the standing issue affecting only the 3rd and 9th appellants. Dealing with the ambit issue, that issue, shortly stated, is whether the facts of the individual appellant's claims are within the ambit of Section 9 of the Cayman Islands Bill of Rights, so as to engage the anti-discrimination provision set out in Section 16. By way of roadmap through this issue, after several introductory points, I will address the ambit issue as follows. First, I will set out what we say is the correct approach to determining whether the facts of a case are within the ambit of a substantive right, so as to engage the anti-discrimination provision in Section 16 of the Bill of Rights. Secondly, I will address your lordships, your ladyships, and our central argument that where the dismissal is because of an immutable characteristic, that, without more, is within the ambit of Section 9. Thirdly, I will deal with the distinctive nature of age discrimination and how we say that should be accounted for in any assessment for the purposes of ambit. Finally, I will address you on our separate argument that the consequences of the discrimination in this case, taken together with the fact of discrimination, are themselves sufficient to ensure this case falls within the ambit of Section 9. So starting with the introductory points, it's agreed that as regards the ambit issue, that the relevant parts of Section 9 and 16 of the Cayman Islands Bill of Rights are materially the same, save in one important respect, as Articles 8 and 14 of the European Convention on Human Rights, and that the board should generally follow the jurisprudence of the Strasbourg Court. The second point is related to the first and concerns the material difference to which I've referred. And if I could invite you to turn up Section 16.2 of the Bill of Rights, which is at page 468 of the bundle, and you will see there what I'll call the protected characteristics listed in Section 16.2. They are identical to Article 8 of the Convention, save for the express inclusion of age and mental or physical disability, which do not appear in Article 8. The inclusion of those two characteristics was deliberate. They were raised by the Cayman Islands Human Rights Committee representative in the formal negotiations for the Constitution in 2008. The relevant record of those negotiations is in the bundle. I don't need to take you to it, but for your reference, the matter was raised in round 1, and that is page 1940 to 1941, and confirmation of the inclusion was raised in round 2, which is at page 1955 at the top of that page. So back in 2008, those framing this constitution took the view that age was of sufficient significance that it should be included expressly in section 16.2. And whilst we have section 16 open, I just also invite your attention to the definition of discriminatory treatment, which starts in subsection 2 as discriminatory means affording different and unjustifiable treatment to different persons on any ground listed. In this case, following the Court of Appeal's rejection of the justification defence, we have unjustified discrimination. The only question is whether that unjustified discrimination on the grounds of age is within the ambit of section 9. My third introductory point concerns the application of section 9 and article 8 to the workplace. In this case, all of the individual appellants were forced to retire at 55. They were at the time office holders, and in accordance with an unwritten re-engagement policy in place at the time, they were offered re-engagements on annual or biannual contracts only if they accepted demotion to the rank of constable. 6 did so, 2 did not. They had no right to be re-engaged. That was a matter of discretion for the Commissioner. It's commonplace between the parties that the protection provided by Article 8 and Section 9 is not confined to the domestic sphere, but can, in certain circumstances, extend to the workplace context. We've set out what we say is the relevant case law at page 107. I'm not taking you to that, paragraph 37 of our case, and the respondents make similar points at paragraph 28 of their case. In the recent Grand Court case in the Strasbourg Court of Denisov, Grand Chamber case in Denisov, a case involving Article 8 only and not an ambit case, the court identified 2 strands of cases when Article 8 was likely to be engaged. I'm going to deal with Denisov in some detail in due course, but it may be helpful at this stage to turn up the relevant part of the judgment at page 742. Before I take my lords and my ladies to the relevant part, let me just set the scene. Denisov concerned the dismissal from his post of the president of the Kiev Administrative Court, although not from his post as a judge. He was dismissed following an investigation for poor administrative performance. He lost his status on the court and he suffered some financial penalty. He brought a claim under Article 8 alone, and the court reviewed the case law relating to workplace cases involving Article 8. And we see that from paragraph 100. So paragraph 100 and 101, the court examines private life in the context of employment-related scenarios. At paragraph 102, it reviews those cases and classifies them into two categories. Firstly, it applies the concept of private life on the basis of two different approaches. Firstly, the identification of the private life issue as the reason for the dispute, the reasons-based approach. And secondly, deriving the private life issue from the consequences of the impugned measure, the consequences-based approach. We say both approaches apply in this case. The consequences approach taking into account also the reasons-based approach and the reasons-based approach alone. The court then went on, and I'll come back to this in due course, to explore the reasons-based approach at 103 through to 106, then explore the consequences-based approach at 107 through to 114. And it made its concluding, and we suggest the ratio of the case really at paragraph 115. I'll come back, as I say, to that, but that's just to set the scene for the workplace context. So those are my preliminary points. I now move to the first headline point under the ambit issue, and that is what we say is the general approach to ambit. I am, of course, conscious that in the United Kingdom Supreme Court, in a range of successive benefit and social security cases, this issue has been ventilated before your lords and my ladies on a number of occasions, most recently in the case of C, for which judgment is still outstanding. So I suspect nothing I say will be new, but we have three propositions which we wish to develop under this head. First, ambit is wider than scope. That is, the ambit of a substantive article is wider than its material scope. Secondly, Article 14 is engaged when there is more than a tenuous connection with a core value protected by the substantive article. Thirdly, Article 14 should be given a wide and expansive meaning, consistent with my latter point, recognising, of course, that it's not a freestanding anti-discrimination provision. The starting point for our submissions is the well-known judgment of Sir Nicholas Bratzer in the Adami case, and the relevant part of the judgment starts at page 522. Before I come to the part that I wish to draw your attention to, it's important just to take a moment about the facts of Adami. Adami is an Article 4 case relating to forced and compulsory labour. The claim concerned a complaint relating to jury service and an allegation that there was discrimination on the grounds of sex relating to the obligation to undertake jury service. Article 4.3d provides that for the purpose of this article, forced or compulsory labour shall not include any work or service which performs part of normal civic obligations. In other words, the article, the substantive article, does not include things like jury service. At the bottom of paragraph 014 and into 015, Sir Nicholas Bratzer makes the observation, and I'm paraphrasing here, given that jury service is not even within Article 4, how can it be that Article 14, which raises issues of discrimination relating to jury service, can be engaged? He answers that question a few paragraphs on in 017, having reviewed the relevant case law. And we rely on the passage in the centre of the paragraph, which starts after the quotation within ambit with the words, thus, according to the constant case law of the court, the application of Article 14 not only does not presuppose the violation of one of the substantive convention rights or a direct interference with the exercise of such right, but it does not even require that the discriminatory treatment of which complaint is made falls within the four corners of the individual rights guaranteed by the article. And just after the footnote 37, the next part we rely on is, this would indicate, in my view, that the ambit of an article for this purpose must be given, and we emphasize this, a significantly wider meaning than the scope of the particular rights defined in the article itself. We say that is unsurprising if one considers the purpose of Article 14 and that it has to be practical and effective. And for that to happen, there must be a real and significant difference between the interference requirements of a substantive article and the ambit. After all, equality is a fundamental principle of human rights, and it's appropriate to give Article 14 an expansive meaning and to construe ambit as broadly as possible to provide maximum protection in cases of discrimination. The requirement in Article 14 for the state to justify differences in treatment between individuals is the minimum that should be expected. The reason for that was explained by Lord Nichols in Godin Mendoza. For this purpose, we can stick with this bundle because it's a short passage. It's page 814, paragraph 9. And I just invite my lords, my ladies, just to read the first 4 lines of that paragraph. My lords, my ladies, I hope I do not do a disservice to the respondents' case when it appears that they seem to be suggesting that age discrimination is somehow less important and less deserving of the treatment that Lord Nichols implies in that paragraph. A useful guide to the current United Kingdom domestic approach in ambit in the context of Article 8 and Article 14 is that of Lady Hale in McLaughlin, which is from paragraph 16 to 22, but I'm going to focus on paragraph 21, which is at page 1241. Just to deal with the brief facts, this was a case which involved the claim that a law that prevented the surviving unmarried parent from recovering widow's allowance, and the claim was that that was incompatible with Article 14 read with Article 8 and Article 1 of the first protocol. Lady Hale here approves the judgment in Smith of the Master of the Rolls, and I pick up the point just after the letters MR. The Master of the Rolls agreed with counsel that the only sure common thread running through the various descriptions of the ambit test for the purpose of Article 14 in the several speeches of M is that the connection or link between the facts and the provisions of the Convention conferring the substantive right must be more than merely tenuous. M is in the bundle. I'm not proposing to take you to it. The indented part of paragraph 21 expands on that in the middle, and this is in the context of what has become known as a positive modality case, but we say nothing turns on that. The state will be in breach of Article 14 if the measure has more than a tenuous connection with the core values protected by Article 8 and is discriminatory and not justified. I also invite you to note Lady Hale's word of caution at the start of paragraph 22. It may turn out this is too restrictive a test. For example, core values as a concept derived from the domestic rather than the Strasbourg's jurisprudence. There's no problem applying it to the facts of this case. I echo those latter words in the context of our submission. We say there's no problem applying it to this case. We are well within, for reasons I'll come on to in the next section of my submissions, the core values of Article 8 in Section 9. I also draw attention to my Lady Arden's judgment in the Steinfeld case in the Court of Appeal, which is at page 1550, paragraph 61. Before I deal with that, I just ought to mention, as my lords, my ladies will know, this went to the Supreme Court. The Supreme Court disagreed with the Court of Appeal on the issue of legitimate aim, but nothing in relation to this paragraph was disapproved. And what my Lady Arden observed there was that in Strasbourg jurisprudence, the core or very essence of a right represents the limits of the state's power. And then reading the next sentence, the next one sentence, it means the convention is only concerned with disputes about which discrimination, which are of the moment and not peripheral issues. And we say that losing one's office because of age discrimination cannot on any view be said not to be of the moment or in any way a peripheral issue. In this case, the Court of Appeal did not address the authorities on ambit. They were cited to the Court of Appeal and they appear in the appellant's skeleton argument for the Court of Appeal at page 389. I don't need to take my lords to it. It's paragraph 24. Amongst others, McLaughlin was cited. Rather, the Court of Appeal based its analysis on Denisov and on the difference as it saw it between age discrimination and other forms of discrimination. As I've already said, Denisov is an Article 8 court case. It wasn't an Article 14 case. It's not an ambit case. And we can see that if we go back to Denisov, and this is page 742, and I'm going to take you through a number of paragraphs where we see what was in the court's mind. So it starts at paragraph 97 in the final part of the final sentence. In commenting on the Pfeiffer case, we see there the reference to the case falling within the scope of private life, and I emphasize the word scope. At page 744, sorry, paragraph 100 rather, at the bottom of page 742, again, we see commentary on the cases falling within the scope of private life. At page 744, paragraph 109, at the foot of the page, again commenting on the case, it's necessary to conclude that the complaint falls within the scope of private life. And then crucially, at paragraph 115, page 746, the heading, Conclusions, the scope of Article 8 in employment-related disputes. The court concludes from the above case law that employment-related disputes are not per se excluded from the scope of private life. we see there the repeated references to scope that Denisov is concerned with that issue. It's right to say that ambit is mentioned twice in the judgment at 103 and 105 under the reasons part of the analysis. But that cannot be being used there as a term of art. It's perhaps one of the examples of rather loose language, but the focus of the, and we see this from the conclusions at 115, is on scope. At Denisov, and we see this going back to page 740 at paragraph 92, Denisov held there's a strong tie between questions of applicability and merits. That's about 5 lines in paragraph 92. The respondent's case is if the claim is inadmissible under Article 8, it cannot be within the ambit of Article 8, or Section 9 in this case. We say that's wrong, and Adami shows it's wrong. Because Adami shows us, if we take the example in that case of jury service, a freestanding complaint about jury service would be outside the ambit of Article 4 and would be inadmissible in an Article 4 case. But link discrimination to jury service, and it comes within the ambit of that article. And when the respondents say, as they do in paragraph 4.3, page 132, and paragraph 31, page 144 of their case, that the applicable test for ambit is that set out in Denisov, they are wrong. There is no ambit test in Denisov. Further, the respondents overstate the appellant's case when they say, whilst, and this is at paragraph 33, whilst ambit may be a wider concept than interference, there is no authority for the proposition that Article 14 is capable of attaching to a matter which otherwise would fall outside the jurisdiction of the European Court of Human Rights. The appellant's case is not that. The appellant's case is simply that the claim may be outside the scope of the substantive article, but within its ambit, thereby giving the Strasbourg Court jurisdiction. We say this point was reinforced by Lord Justice Leggett, as he then was, in the case of C. That's the tax credit case, which is now before the Supreme Court and for which judgment is awaited. And I'm aware that ambit was ventilated in that case, but we say that his analysis at paragraph 44, which is page 1459, has much to commend it. And we pick up the point halfway through that paragraph. This approach, that's the approach of the Strasbourg Court, treats each of the convention rights as surrounded by a penumbral area in which, and this is the crucial part, it meets the respondent's point, the right itself is not engaged. Action by the state, although the right itself is not engaged, action by the state must not violate Article 14. That tells us that the substantive article does not have to be engaged, but Article 14 may still come into play because the complaint may be within the ambit of the substantive article. Now it's a small point, but a point to finish off this issue under our first headline point is that the European Court of Human Rights produces a guide for legal practitioners, and that is in the bundle relevant extract at page 1961. Just to go back actually to 1960, my lords, my ladies will see from the first 2 or 3 sentences the purpose of this document. It's a series of case law guides published by the European Court to inform legal practitioners about fundamental judgments and decisions. And it's of note at page 1961, right at the bottom in paragraph 4, the material scope of the application of Article 14 is not strictly limited to that of the substantive provision. And moving in a little further, at paragraph 10, page 1963, in the second part of that paragraph, just after the case law has been cited, as such, the material scope of application of Article 14, read in conjunction with a substantive provision, cannot be reduced solely to the material scope of application of the substantive provision. That, in essence, my lords, my ladies, is our case on the general approach to ambit. I now move to the second headline point, and that is that dismissal because of an immutable characteristic is within the ambit of Article 8 without more. This is the core of our submissions on ambit. Before turning to the authorities, I'm going to set out 4 propositions that we advance. First, an immutable characteristic, such as sex, leaving aside transgender issues, race, age, sexuality, are part of an individual's personal and physical identity. It's something about themselves that they cannot change. I do not anticipate that point to be controversial. The second proposition is that personal and physical identity is protected by Article 8, Section 9. The third proposition is that dismissal from employment, or in brackets even demotion, for a reason related to a person's identity, including sexuality, sex, race, age, has been held to amount to an interference with Article 8. If a dismissal or demotion for a reason related to a person's identity amounts to an interference, this is my final proposition, if dismissal for a reason related to a person's identity amounts to an interference, it must be within the ambit of Article 8 and therefore engage Article 14. We've set out the case law we rely on at paragraph 40 to 69 of our case, and I'm not going to take you through every nuance of that. I invite you to review it at the appropriate time. What I'm going to do here is highlight what we say are the leading cases which set out the principles and propositions which I've just summarized for you. The starting point is the well-known Smith and Grady case. That is the case of homosexuals dismissed from the armed forces because of a blanket rule which was to the effect that homosexuals could not serve in the military. We pick up that judgment at page 1718. Paragraph 71. The second part of that paragraph, which starts in these circumstances. In the first part, what the court does is examine and refer to the intrusive investigations and interviews the soldiers and airmen had to undertake to during the process of investigation into their sexuality, and held, unsurprisingly, that that constituted, as it says in the end of line 4, a direct interference with their right to respect for their private lives. Nothing surprising about that. However, the next sentence says this: their consequent administrative discharge on the sole ground of their sexual orientation, and we emphasize the next word, also constituted an interference with that right. What we say the court is saying here is two things. One, you have the intrusive investigation, which of itself interfered with their private lives. But secondly, and separate to that, you have the sole reason relating to the immutable characteristic of sexuality, which also, i.e. in addition, constituted an interference. The next case we draw my lord's, my lady's attention to is the case of Boyraz, which is in the bundle, and the relevant page is page 634. Before coming to that, dealing with the facts, Boyraz was a case where a woman had passed the civil service exams in Turkey and was assigned at her choice to work in security for the state power company. She and 3 other women were told they could not do so because those positions were not open to women. Another blanket rule, barring in this case women from that particular role. Paragraph 44, having looked at the circumstances, the court says this: it reiterates that the authority dismissed the applicant from her post on the grounds of her sex. In the court's view, the concept of private life extends to aspects relating to personal identity, and a person's sex is an inherent part of his identity. Pausing there, that makes good, we say, our second proposition about aspects of immutable characteristics are being part of a person's identity. It then goes on to say, thus a measure as drastic as dismissal from a post on the sole ground of sex has adverse effects on the identity, self-possession and self-respect, and as a result, his or her private life. And the court then says, the court therefore considers the applicant's dismissal on the sole ground of her sex constituted an interference with her right to respect for her private life. Pausing there, if you substitute age for sex, you arrive at the position we are in, we say. And then the court, similar to the approach in Smith and Grady, says besides, and then looks at the consequences of that dismissal. So what we say in Boyraz, consistent with Smith and Grady, is you have a reason relating to an immutable characteristic as being a specific standalone reason for the engagement of Article, the interference with Article 8. Boyraz was in fact an Article 14 case read with Article 8, and it was held to be an interference. For your note, that's at paragraph 56. I now turn back to Denisov. As we've already explored, and this is page 743. Denisov at paragraph 102 set out the 2 approaches, then 103 explored the reasons-based approach. And at paragraph 104, it cites Smith and Grady as being an administrative discharge on the sole ground of sexual orientation. But if we go back to 103, it's important to focus on the words the court uses in this paragraph. Complaints concerning the exercise of professional functions have been found to fall within the ambit of a private life. And this is the crucial part, we say, when factors relating to private life were regarded as qualifying criteria for the function in question. In other words, not being homosexual in Smith and Grady, not being a woman in TDAS, being below the age of 55 in our case. A qualifying criteria for the function in question. The qualifying criteria in this case was that you had to be aged 55 or under to continue in your rank and in your office as a police officer below the rank of inspector in the Cayman Islands. As I've mentioned, Smith and Grady is cited. Ospinar is another case cited. That's in the bundle. That concerned a dismissal of a judge following an investigation undertaken into her private life. I'm not going to deal with that. It's dealt with in our written case. The second case cited, and this is towards the end of paragraph 104, is the case of Sodan. I'm going to pick up that case of Sodan in a minute because it, we say, is important, and there are some interesting and relevant features for our case. But before we move away from Denisov, there are a couple of other points I want to make. One specific point is, and that is that under the reasons-based approach, there is no requirement to examine the consequences. And to make good that point, I invite you to look at page 744, paragraph 109. Where no reasons-based approach justifies the applicability of an Article 8, an analysis of the effects of the impugned measure on the above-mentioned aspects of private life is necessary. In other words, you only examine the effects if you're looking at the consequences approach and not the reasons-based approach. We see that again in paragraph 110 at the start. In cases where the court employs the consequences-based approach, an analysis of the seriousness of the impugned measure's effects occupies an important place. It's not a matter which is considered in the reasons-based approach. Paragraph page 746, paragraph 115, halfway down and into 116. So halfway down, again revisiting the analysis, there are two ways in which a private life issue would usually arise in such a dispute. And then we've dealt with that. Then at the start of 116, if the consequences-based approach is at stake, the threshold of severity with respect to the above-mentioned aspects assumes crucial importance. But again, implicitly not with the reasons-based approach. So in the consequences-based approach, you look at the effects. In the reasons-based approach, the mere fact that a person has been, we say in this case, dismissed, or a reason relating to an immutable characteristic going to their identity is of itself sufficient without examination of the consequences. I said I would pick up Sodan, which we say is an interesting case from our perspective. Before I go to it, I'll just identify the page for you. It's page 1743. Before I deal with it, let me just deal with the facts. The case concerned an applicant, civil servant, who was a deputy prefect in Ankara in Turkey, in the capital city. He was not dismissed, but he was moved from the capital city to a less important and less prestigious post in a provincial city. And the reason he was moved was because of his religious beliefs and his wife's religious dress. He brought claims under Article 8 and Article 9, although not Article 14. If one looks at paragraph 43, this is page 1743, sorry, I think I just bear with me, I think it's page, sorry, 1745, paragraph 43. We'll see there the facts that I've just described them. The petitioner was transferred from as a deputy prefect in the capital to another post of deputy in a provincial city was smaller in size. Whilst this was in principle a customary measure during the career of a civil servant, it's nevertheless the fact this may have a negative effect on his career, notably being transferred to a less prestigious post. Just pausing there, in some ways that can be seen as akin to a demotion. Of course, the existence of these negative consequences alone is not per se sufficient to lead to the transfer running contrary to the rights guaranteed by the Convention. What is important is to determine the grounds for the transfer and check whether those were compatible with the provisions of the Convention. And those are then picked up at paragraph 49 and 50. Taking account of the circumstances, etc., there is a clear link of causality between the private life and beliefs of the petitioner on the one hand and his transfer on the other. The court believes the transfer constituted a sort of disguised sanction, or in other terms, a measure without formally falling in the remit of a disciplinary measure, shows an intention of the perpetrator to sanction the agent by harming his career on the basis of arguments made against him, notably his lifestyle, his beliefs, and the clothing of his wife, and constitutes, paragraph 50, an act of interference. We say that is significant for our case because it might be said, and it was certainly said in the court below, that actually the appellants were not dismissed, their terms of engagement were merely modified. We would reject that out of hand, a forced retirement and dismissal of office and replacement by re-engagement on annual or biannual contracts is, on any conventional view, a dismissal. But even if that argument were to find some favour with the board, we would say that Soden's case shows that something akin to a demotion would be sufficient to interfere with Article 8 and therefore obviously come within the ambit of it. The third case I want to take my lords and my ladies to is the Novakovic case. Page 1298 is the relevant part. Again, I'll deal with the facts first. Novakovic is the most recent Strasbourg decision in the bundle. It's from December of 2020. And it's a case which age is expressly recognised as being part of a person's physical identity. In that case, an ethnic Serbian teacher in Croatia was dismissed from his post because he was teaching the Serb dialect rather than standard Croatian, and it was determined that he was too old to learn standard Croatian, and so wouldn't, as it were, change his ways, and was dismissed. Paragraph 48 and 49 on page 1298. Starting at 48, the court observed the direct reason for the applicant's dismissal was that he'd used the Serbian language and so on, and then on his alleged inability to adapt his language instruction to the requirements of his post due to his age. The court then deals with the language aspect, and then after the citation of the authority, it says this: moreover, a person's age obviously forms part of a person's physical identity. we rely on that for obvious reasons. And then at 49, given that the crucial reason for the applicant's dismissal deals first with the language, and then in the second line, the perception that he could no longer change, this feature was directly linked to his age, the court is satisfied that the underlying reasons for the impugned measure had been sufficiently linked to the applicant's private life. And that was held to constitute an interference. My Lord, Lord Stevens.
Is there any Strasbourg authority that deals with age alone, not linked to anything else, as a reasons-based so as to fall within Article 8?
My Lord, there is a case, and it's a case against us, and I'm going to come to it. It's a case of JB. It's not a particularly helpful case from our perspective, but I'm going to come to it. But I would, in answer to my Lord's point, just invite my Lord to have regard to Novakovic, because whilst there are two reasons, age was itself a standalone reason. And we see that from the part I've just taken to paragraph 48. And we see it by reference to the link to age in 49.
I was just wondering whether it could be said that it moreover, a person's age, was that a connection to the earlier reason?
My Lord, I would say not. I would say what the court is saying there is that is taking, as it were, age on its own and saying, in any event, age obviously forms part of a person's physical identity. It's a separate, and I would submit it stands to reason. When I say the case I'm going to come to, which is the one cited, JB and others, I say it's against us. It's against us in the result, but in fact, it's not against us in the reason point, which I'll come to. Before I get to that, before I come to JB, which is in fact cited in Novakovic, what I'm just take stock at this point. What I say, the authorities that I've taken you to rather clearly show is one, identity is protected by Article 8. That if we look at Novakovic, age is part of a person's identity, and dismissal, and indeed even demotion, or something equating to motion, on the sole ground, is linked to the core values of Article 8, and it amounts to interference. I'll end the suspense and take you to JB at 900, my Lord. And this is a case which, sorry, it starts at 900. In fact, the relevant passage I'll be taking you to is it's a little further on. Before I do, this is a case, a retirement age case. It's a case of Hungarian judges who were required to retire when the minimum retirement, so the minimum retirement age rather, was reduced from the age of 70 to 65 in 2012. And that forced judges who were 65 at that date to retire by the middle of that year, and those who would reach 65 in that year to retire at the end of the year. By way of backdrop, it concerned both judges and state prosecutors, I ought to say. The judges brought a case in the European Court of Justice and were successful. Hungarian law was changed prior to this case being heard, and judges were given various options, including the right to be reinstated and have their back pay paid. At page 930, we see the claim was brought under Article 14, read with Article 1 of the first protocol. And then at paragraph 112, there was a standalone complaint under Article 8. So the Article 8 claim was not linked to Article 14. So far as Article 8 is concerned, the ambit question was not raised. 935 is the relevant paragraph for our purposes. And this answers my Lord Stephen's question. The direct reason behind the applicant's dismissal was that they had reached the lowered mandatory retirement age applicable to them. Although a person's age is obviously an aspect of her physical identity, it is at the same time an objective fact, not capable of being influenced by freedom of choice in the sphere of private life. Now, just picking that paragraph apart, the first point is it's clearly authority for the proposition that age is part of identity, and it was relied on that in the Novakovic case for that purpose. I have to confess I have some difficulty with the second part and what that is supposed to mean, because that applies to any immutable characteristic. It applies to race, sexuality, or sex. It's an objective fact not capable of being influenced by freedom of choice in the sphere of private life. No other factors relating to the private life goes on. Now, the problem we have with this case and why we say the board should not follow it or apply it is the court there, the Strasbourg court, has identified a reason. It is a reasons case. Notwithstanding that it is a reasons case, and notwithstanding that it was decided after Denisov, with all the analysis of the Grand Chamber that is set out therein, this chamber decided to approach the case as a consequences case. We say that simply doesn't follow Denisov. We've set out in detail those points in our case, and we repeat them. This is a reasons case. It should have been resolved as a reasons case. It makes no sense to resolve it as a consequences case when you have Denisov. And it's notable that Novakovic followed it as if it were a reasons case. As I say, we can speculate about this. It may be the court took the view that the judges had been fully compensated and been successful in the European Court of Justice, or whatever. We have no knowledge of why that is, but it doesn't follow the approach in Denisov. And I just remind the board, as was said by Lord Hughes in the Lendor case, which is in the bundle, the board's not required to follow every turn of Strasbourg case law. This is a particular turn which we would invite the board not to follow because it's simply not consistent with Denisov in particular. And finally, of course, it's not an ambit case, so the board isn't required to apply it for that purpose. As I say, and bringing this part of our submissions to a close.
Mr. Chubb, why do you say it's not an ambit case if this was a case about the combined effect of Article 14 and A1P1?
It's not an ambit case for the purpose of Article 8, I meant, my lord. Ambit wasn't considered in the context of Article 8.
Oh, I see.
It was
Thank you.
considered in Article 1, A1P1, but for the purpose of Article 8, it wasn't an ambit case as I read it. So, ending my submission with the weight of authority, we say strongly supports the proposition that dismissal, or in brackets, demotion for reasons relating to personal identity is by itself sufficient to amount to interference. And we note and we remind my lords, my ladies, that in section 16(2) rather, age is specifically identified. Age sits alongside other protected characteristics. It sits alongside those protected characteristics without qualification. There is no warrant, we say, for treating age any differently in respect of ambit. And we'll come on to why we say that in the third headline point that we now come to, which is what we say is the correct way of dealing with the distinctive nature of age discrimination. And in short, we say that is through the filter of justification. The Court of Appeal, in this case, explained their reasoning at page 258, paragraph 33. And I hope I don't do a disservice to their reasoning when I say they identified the following factors as being important. Firstly, they say a blanket retirement related to age says nothing about an individual. Well, dealing with that point first, that's the same for any blanket rule. If there had been a rule which said women are not allowed in the police force, that would have been a blanket rule which took no account of personal individual characteristics, said nothing about the person who was affected. That is the nature of blanket rules. They rest on stereotypes, usually derogatory stereotypes relating to individuals. That is why they are often so offensive. The second reason the Court of Appeal relied on was to suggest that age discrimination by retirement is not as serious as other forms of discrimination. Miles away, they use the expression. I'll come to that because we want to meet that point head on. The third reason is that there were no particular serious and individual consequences. On this point, we say, for the reasons I've already explained, that is unnecessary for ambit. But in brackets, and in any event, we say there are sufficient consequences here when taken with the reason itself to meet the ambit threshold. That forms my fourth headline point, which I'm going to come to after I've dealt with this section. The respondents say that the reasons-based ground for concluding that section 9 is engaged, there is no reasons-based ground for concluding that section 9 is engaged. As a basis for discrimination, age is not a suspect characteristic and does not require protection of the nature and extent applicable to race, gender, or sexual orientation. Well, the obvious difficulty with that point is that there's no such distinction in section 16 that says, in brackets, age only if it's really, really serious, or only if it's of this nature, or only if it's this kind, or only if it's personal to the individual, rather than a blanket rule. We say that that is completely the wrong way of approaching this issue. First, we accept age discrimination is different, but it is no less serious. Secondly, the different nature of age discrimination is, and in the case law has been, taken account of not at the ambit stage, but at the justification stage of the analysis. Dealing with the nature of age discrimination, we make the point at paragraph 74 of our case that discrimination, which was once unremarkable, is now prohibited. I've set out in our case a table indicating in the United Kingdom when the major pieces of anti-discrimination legislation were introduced. Age discrimination in the United Kingdom has been prohibited for 15 years on the same basis as any other protected characteristic. In the Cayman Islands in 2008, age discrimination was being raised in the negotiations for the new constitution and was implemented because it was thought sufficiently serious to warrant express protection. In the employment tribunals in the United Kingdom, injury to feelings awards have been made in retirement cases for the last 15 years. As was said by Lord Bingham in Ex parte Smith, which became Smith and Grady, a belief which represented unquestioned orthodoxy in year X may have become questionable by year Y and unsustainable by year Z. For your note, that's at page 1431. In the leading case in the United Kingdom on age discrimination retirement, that is the Selden case, at page 1629. Lady Hale, at paragraph 15, addressed the issue of the assumptions about age, and I invite you to read that paragraph to see what she agrees with there, and we invite you to have those same issues in mind and to put out of our minds any stereotypical assumptions about age.
I'm sorry, Mr. Buck, could you give me that page number again?
1629,
Thank you.
paragraph 15.
Thank you.
Age discrimination is different, not because it's less serious, but because, unlike, for example, race and sex, it's recognized that there may be rational and acceptable reasons for discriminating on the grounds of age which have nothing to do with the individual, but may be in the interests, the social and economic interests of wider society, which wouldn't apply to those other protected characteristics. That was explained by Lady Hale in Selden at paragraphs 3 and 4, which are at page 1626 into 1627. In there, she, accepting the proposition put by Miss Diana Rose QC, that age is different because it's not binary, it changes over time. This means that younger people will eventually benefit from provisions which form older employees and so on. The key point we make about that is, well, when do you take account of these issues? Do you take account of these issues at the ambit stage, or do you take account of them at the justification stage? We say it's self-evident. They're precisely the sort of issues, social and economic issues, for which a rational, structured analysis of the kind undertaken in the justification analysis is required. It's not something that lends itself to the more nebulous concept of ambit. And indeed, Selden, of course, is concerned, obviously, with different legislation in a different sphere with justification. Just because age discrimination can be justified on wider social and economic grounds does not, of course, mean that those who are the victims of such discrimination do not feel and may not feel that discrimination keenly. Court of Appeal in this case relied on observations about age discrimination in a number of historic cases. The first case cited was the United States Supreme Court case of merger, the well-known case of merger, decided some 45 years ago. I'm going to come to merger in a moment. What we say about that, and that was the well-known point that age was not within the suspect class. What we say about that is that even then, on proper analysis, what merger is doing is identifying the correct approach to justification. Does it require the strict scrutiny of the suspect class, or does it require the rational basis which applies to those types of discrimination outside of that class? And it was held that rationality was the proper standard. It's worth noting in merger, which I'll take you to now at page 319. Actually, that doesn't, sorry, forgive, it's not 319. Bear with me a moment. It is 1202. 1202. It's worth noting at 1202, paragraph 317 of the judgment, and this is again, I repeat, is some 45 years ago, the United States Supreme Court recognizing the effects of mandatory retirement ages. I invite you to read the sentence, the paragraph starting with the sentence, "We do not make light." It's also worth noting, as we've set out in our case, that in the 45 years since merger, there has been no other entry to the suspect class. The only characteristic in the suspect class is race. Back in 1975, Mr. Justice Marshall identified that at paragraph 319, that the court had apparently lost interest in recognizing other fundamental rights. So as a guide to suspect class, this is not a particularly reliable guide when the suspect class is not opened at all in the United States. In our case, I have mentioned, or we have mentioned, Lord Hoffman's observations on merger in the Matadine case. I'm not going to take you to that because it rather repeats the point I just made about the nature of the inquiry for the purposes of justification. But for your note, that's at page 1222, letter D to F. My lords, I see the time. That's an appropriate moment because I'm now going to move on to examine the case of Carson. And I'm going to do so with some detail. It may be, I think, appropriate for you to have that available in the supplemental bundle after the break.
Thank you very much, Mr. Chuck. We'll resume in 5 minutes, just before 10:02. Did you hear, Mr. Chuck?
My lord, I have just now, yes, my lord. Thank you.
Please
my
continue.
lord, thank you. I'm going to move to the Carson case. Just before I do so, my learned junior, Mr. Roboter, made a point to me over a short adjournment in relation to the question Lord Stevens asked. I won't take you back to Nova Coe, but I just invite the board, when considering the point that was raised, that the first part before the word "moreover" in that sentence was dealing with ethnicity. The second part was dealing with age. The two are completely unconnected. Age and ethnicity bear no relationship to each other. So it's quite clear when one thinks about it in that way that they are talking about two different things and not rolling up the two issues together. I said I'm coming to Carson and Reynolds now in the House of Lords some 16 years ago, and just to take stock of where we are, what I'm dealing with here is what we say is the correct way of dealing with the distinctive nature of age discrimination. As I say, it's the supplemental bundle if you have that open. And just to give you the background first, case concerned two cases, Carson and Reynolds. We're concerned with Miss Reynolds' case. She was aged under 25 and was concerned with the fact that payment for job seekers allowance and income support was paid at a higher rate for those aged 25 or over. It was a claim brought under Article 8 and Article 1 of the first protocol, read with Article 14. The starting point that I want to take you to is page 121, the speech of Lord Hoffman, paragraph 16 and 17. So what he is doing here is firstly, having dealt with the merger case, which I've just dealt with, and dealing with the distinction that is made in that case between the strict scrutiny requirements and the rational basis requirements of what I've termed justification in that case. He describes the approach that should be taken at paragraph 16. So in relation to the suspect class, discrimination in the first category cannot be justified merely on utilitarian grounds, and then expands on that. Then on the other hand, differences in treatment in the second category, i.e. those not in the suspect class, usually depends on considerations of general public interest. Paragraph 17, he says there may be borderline cases in which it is not easy to allocate the ground of discrimination to one category or another. As I observed, there are shifts in the values of society on these matters. Gaydon against Godin Mendoza recognized that discrimination on the grounds of sexual orientation is now firmly in the first category, pausing there, certainly in the United Kingdom, although it's yet to find its way into that category in the United States. Discrimination on the grounds of old age may be a contemporary example of a borderline case. That was said some 16 years ago. My lords, my ladies, I suggest that we are well now beyond that stage. It's right to say, whilst I've got the judgment over at page 132, Lord Walker observed paragraph 60. Age is a personal characteristic, perhaps answering my Lord Stephen's point, but then goes on to say it's different in kind from other, and he expands on his reasoning. But he then says this: there's nothing intrinsically demeaning about age. That may have been an approach, as I say, some 16 years ago. It's difficult to see that that would be an approach that was one to adopt today in 2021. Just because aging happens to everyone, it does not mean that everyone is affected by aging to the same degree at the same time. A fit police officer who is required to retire at 55 may feel demeaned when he looks at a younger, unfit colleague who isn't as able as he or she is and says, why do I have to leave my vocation, my office, my profession, when the younger, unfitter colleague does not? He may well feel demeaned. I make that submission, conscious as I am of the different retirement ages of the board, of course. Although I understand the law's about to change in that respect. But the most interesting thing we say about Carson and Reynolds for our purpose is how age discrimination is dealt with. The House of Lords did not determine the Miss Reynolds claim did not determine whether or not Miss Reynolds' claim fell within the ambit of Article 8 or Article 1 of the first protocol. What it did was look at the reasons for the discrimination and filtered that through justification. And Lord Walker explained this, and this is a paragraph, a section rather of his speech we particularly rely on, page 131, paragraphs 57 and 58, again, dealing with this vexed issue of which characteristics are or are not within the suspect class, citing merger, discussing that issue. Then at paragraph 57, as I have said, these distinctions are not so clearly signalled in the jurisprudence of the European Court of Human Rights. But counsel for the Secretary of State submitted, in my opinion, correctly, that the equivalent doctrine is found here. Now, found there. Just pausing there. The court could have said, the House of Lords could have said, the equivalent doctrine is found there, and it's at the ambit stage. We weed out non-suspect class cases at the ambit stage. It didn't say that. What it said is that where there's an allegation that Article 14 has been infringed by discrimination on one of the most sensitive grounds, severe scrutiny is called for. And we see the citation from Gaydon Mendoza again, and that then is developed through. In other words, what Lord Walker is saying, in clear terms we submit, is that you deal with the different nature of age discrimination through justification. And he deals with how he dealt with age at paragraph 60, talking about it being of a different nature, as I've already taken to that paragraph. But we see the same approach in each of the speeches of each of the law lords, save for Lord Carswell, who did not address the issue at all. So I'll take you to those. The first is Lord Nichols, page 118, paragraph 3. I invite you to read that to yourselves, and I submit that what he does there is filter this issue through justification. And we see that from the last sentence. Reference to legitimate aim and proportionality. Page 127. Paragraph 41, Lord Hoffman. I think it's fair to say Lord Hoffman didn't think much of Miss Reynolds' case. If we pick it up at the middle of the paragraph, if one wants to analyse the question pedantically, a person one day under 25 is an analogous, indeed virtually identical situation to a person age over 25, but there is objective justification for such discrimination. So again, filtering this issue through justification and not through ambit. And we make the point, the obvious point, that the police officer age 56 is in exactly the same police position as a police officer age 55. On this, just over the page, Lord Roger, taking the same approach towards the end of that paragraph, drawing the bright demarcation line at 25 was simply one part of the exercise. It follows that the difference in treatment of which he complains easily withstands scrutiny, and there's no unlawful discrimination, having gone through the factors relevant to the proportionality exercise. I've dealt with Lord Walker. For your note, there's a fuller discussion of this at 84 to 91, but I don't need to, which is page 139. I don't need to take you to that. I've made the point with reference to Carson, which is Carson, we say, is a clear guide to how you deal with the different nature of age discrimination. And in a sense, it doesn't much matter whether or not you regard age being within the suspect class or not. The fact is, whatever class or how you classify age discrimination, you deal with it through justification. Indeed, it's of note that in this case, in the Court of Appeal at page 265, so just going back to the electronic file, so in the other file, at page 265, when dealing with the issue of justification, which the Court of Appeal rejected, paragraph 50 at the bottom of the citation from Bank Mellet, it would also have had to bear in mind that age not being a suspect characteristic for the reasons already advanced, questions of social and economic policy might readily be deployed to justify the retirement policy. That's interesting, because what the Court of Appeal is doing is using what it says, age not being within the suspect class, both at the ambit stage and at the justification stage. We say that can't be right. The proper place to do it, we have no objection to the, we have an objection to the classification of age being suspect class, but we have no objection to the Court of Appeal addressing it at this stage in that way, because that is the appropriate place to address it. And having addressed it, it rejected the justification defense. Going back to the Strasbourg authorities, the issue of age was raised in the Gurkha welfare case. This is at page 664. This was a case relating to the length of service, so not strictly about age, that retired Gurkha soldiers were entitled to certain pension benefits. And at paragraph 88, the court has recognized that age may constitute other status for the purpose of Article 14 of the Convention. That's how the Strasbourg court deals with age. It puts it with the other status provision. Although it does not today suggest that discrimination on the grounds of age should be equated with the suspect grounds. Nevertheless, even if it were accepted that older Gurkhas were treated less favourably than younger Gurkhas on account of their age, the differential treatment, reading on, must be regarded as objectively and reasonably justified. In other words, it didn't say, the Strasbourg court didn't say, well, this is an ambit point, it's not in the suspect class, therefore it's not within the ambit. It considered the matter, and it considered the matter under Article 14. I ought to say that's, of course, read with A1P1 rather than Article 8. Finally, just again on a slightly different point, but at page 1469, this is the case of C, which I've already dealt with. Again, the judgment of Lord Justice Leggett as he then was. If one looks at paragraph 78, now this was the argument that the claimants were within within a protected group, and he talks about that in that context. And then how does one deal with that? Having found the claim was within the ambit, he says, this is generally not a matter which involves any other choice. It's not a classification of a sensitive or suspect kind, which requires particularly weighty reasons to justify making it a ground for treating people differently. Again, we see even with that rather stretched version of other status, the court is still filtering that through justification. Having found the claims were within ambit, filters them through justification. What all of these authorities demonstrate, we say, is that the distinctive nature of age discrimination, and in particular that it can be justified on social and economic grounds, should not be used as a reason to filter cases out at the ambit stage, and the respondents are completely incorrect on that analysis. To attempt to filter out at the ambit stage is illogical. It fails to accord age the same status as other protected characteristics in section 16, and it's a recipe for uncertainty. You don't need to do it. You have a ready-made system for rational assessment of the reasons for discrimination. It's set out in section 16. That finishes my submissions under my third headline point about how we deal with the distinctive nature of age discrimination. If you're with me on my submissions at this point, you don't need to consider anything I say after this point because our case will be made good. But I'll complete my submissions. Forgive me, my Lady Rose.
Can you just explain how this would apply in a case of a private company imposing a mandatory retirement age of 55? How do there are many companies that have retirement policies similar to this one. Do those also somehow engage convention rights, and if so, how? And if not, isn't one then creating quite a marked distinction between the rights of people employed by the public sector and people employed by the private sector?
My lady, forgive me, my lady, in relation to that, I'll say two things. Firstly, in relation to the convention rights in the United Kingdom, for example, the requirement would be the courts would have to apply the Human Rights Act, which would means it would have to deal with any challenge in that way, in that context. And the same would apply in the Cayman Islands, that the court, if it was a private company and issue was taken with it, the court would be bound to apply the Bill of Rights to that situation. So there would be no difference. It doesn't arise in the United Kingdom context because, of course, we have the Equality Act, and as Selden makes clear, that in the United Kingdom, although in 2006 there were standard retirement ages in private and public sector companies, they've all fallen away pretty much now, unless they can be justified. And so people now are challenging. If they challenge, it'll be on the basis that the standard retirement age is too low, and those challenges generally either succeed or fail on the merits in relation to the justification test. But to answer my lady's question directly, the short point is that the courts in the Cayman Islands would be bound to apply the Bill of Rights in that scenario to any challenge. And so if that act contravened the Bill of Rights, then that would be, in our submission, the position. My lady, I think lying behind my lady's question is obviously the practical effect of this. But my lady, I wouldn't, if I may say so, be too alarmed by that. It is not a difficult exercise to justify a standard retirement age. And it's not a difficult exercise, providing it's set at the right level. The reason why the justification failed in this case was because after 2010, the law changed. So in effect, you had two different retirement ages for people doing the same job. In Selden, and this is I accept in the context of the framework direct in the European Court, there are a series of cases set out of standard retirement ages which the European Court of Justice is concerned, and only one of those, a Lufthansa pilot's case from recollection, was a standard retirement age not justified. Had the law changed in the way it subsequently changed in 2016, where officers were given the choice either to retain their original retirement age or to work until 60 and possibly 60 or 65, subject to medical and physical examination, then there would have been no challenge, because that would have taken account of it. It was the change in the law, which meant that you had two people doing the same job who could retire at different times, that led to the challenge. But the standard retirement age, the threshold for justifying that is not particularly demanding and would, in many cases, be readily met, my lady. I ought to say there isn't an equivalent of the Equality Act in the Cayman Islands. There is a Gender Equality Act, and there is a provision in the labour law making discrimination a criminal sanction, the General Anti-Discrimination Clause in Section 80, but there's no overarching Equality Act in the Cayman Islands. I come to my fourth and final headline point under the ambit test, and that is that we say in any event there is sufficient evidence of consequences taken together with the fact of discrimination for the appellant's case to come within the ambit of Article 8, Section 9. This argument rests on three propositions. Under the consequences limb of the Denisov approach, it requires a minimum level of severity where there is a very serious effect on private life to a significant degree for both the article to be applicable and for it to be interfered with. So in other words, to succeed on a freestanding Article 8 claim, that's what you have to establish. But because ambit, and this is the second proposition, because ambit is wider than scope, it must follow that something less than that level of serious severity of consequences is required in order to be within ambit. And we say the facts of this case, whilst we accept we haven't appealed the point, are not sufficient to amount to interference with Section 9, there's enough in there taken together with the fact of discrimination to come within the ambit of Section 9. I will deal with some of the facts, and of course I'm acutely conscious of the board's, the board is not going to be interested in revisiting the findings of fact or anything. I'm not seeking at all to persuade the board to do that. I'm just going to flag up some crucial, we say crucial facts within the judgment to make good the submission that we have indicated. Firstly, page 169, paragraph 30, the third appellant, who is an inspector required to accept a contract as a constable, said that apart from financial loss, he felt embarrassed serving at a lower rank. We can ignore the bit about British officers, that point isn't proceeded with. Over the page, the 31, he expressed feelings of humiliation and dejection, as it appeared as he's had a demotion. And 33, he felt embarrassed to return to work as a constable. Page 196, the third appellant said something similar at the bottom of paragraph 106. Forced retirement had been degrading on her personal relations and somewhat like a bereavement. And at page 231, at paragraph 213, this is the judge's findings that she found as a fact the second plaintiff found it embarrassing to be re-engaged. It was also accepted that many officers, including the commissioner, would find such a reduction in rank embarrassing. She found there was no suffering of reputation, and that his embarrassment, that of the second appellant, was not due to any treatment he received from others. In relation to the third appellant at 235, the judge held, sorry, at page 235, paragraph 229, that the relationships changed. The judge didn't accept that there had been significant deterioration. It merely changed because they saw each other less frequently. Paragraph 236, page 236, rather, paragraph 231, the judge held that the embarrassment experience was not, despite initial embarrassment, the second appellant stated his colleagues still showed him respect. And she, right to say, to give you the complete picture, 233, said there was no stigma or reputational damage. At page 195, going back a bit in the judgment, the commissioner, when cross-examined, agreed at paragraph 104 that it was an indignity for a sergeant or an inspector to return to work as a constable. And at page 173, paragraph 41, the third appellant gave unchallenged evidence that she had suffered some financial loss. I ought to say the agreement between the parties was that the second and third appellants cases would be taken as representative of the group as a whole. But what we say there is, whilst the courts have held against us that those facts were sufficient to amount to an interference, one has to have a look at the context. You have a small police force, hierarchy is important, rank is important, close relationships are formed in demanding circumstances, and the officers interact with the public on a daily basis. So an officer coming into work and seeing a member of the public one day who sees him an inspector and sees him as a constable the next day is going to wonder why. Now, as I say, we are bound by the findings of the court and the Court of Appeal in relation to not meeting interference, the interference standard of section 9. But interference is not the same as ambit. And if you take those baseline facts, the embarrassment, the indignity, the context, taken together with the fact of unjustified discrimination, you have, we say, a sufficient and more than tenuous link with the core values of Article 8. Because you have the discrimination on the grounds of age, and Denisov makes it clear you can take both into account, both reasons and consequences. And you have the fact of discrimination as well. I ought to say, just for your note, I won't take you back to Denisov, but that's paragraph 109 of Denisov, where they talk about courts adopting both the reasons and consequences approach together. The respondent relies on an English Court of Appeal case, Vining, which is a collective redundancy case decided by the Court of Appeal, in which it held that the collective redundancy in that case of Park's police officers was not within the, did not engage Article 14. We distinguished that case on the basis that it didn't concern age discrimination. There was no issue of age discrimination in that case. It did not concern dismissal for reasons related to a person's identity. It was redundancy not forced retirement and removal from office of an office holder, as this case is. It was decided before the classification that Denisov undertook. In short, we say whether the facts amount to an interference is a different question than whether they amount to the necessary standard to come within the expression ambit. Those end my submissions on the ambit issue. And just to summarise, ambit is wider than scope. A claim can be outside of the scope of the article, but within its ambit. Point 2, dismissal because of age is a dismissal for a reason relating to a person's identity. Point 3, dismissal for such a reason is by itself and without more sufficient to amount to an interference with section 9 and therefore certainly comes within the ambit of that section. Fourth point, as regards consequences, the consequences here, even though not sufficient to amount to interference, are sufficient when taken together with the fact of discrimination to come within ambit. Those are my submissions on the ambit issue. I'll now turn to the section 19 issue. The section 19 issue only arises, of course, if you're against me on all of my submissions to date, because it's concerned with the re-engagement policy. And just to orientate ourselves in relation to that, could I invite you to turn at page 476? That is the relevant section of the domestic legislation. It's paragraph 20, subparagraph 1 of the 2006 police law. So it imposes the retirement age of 55. And it says, without prejudice, they're being accepted for such further periods or periods of service as may be fixed by contract. That gave the Commissioner of the Police the power to engage officers after the age of 55, not as office holders, but on contracts. And he exercised that power in an unwritten, unofficial re-engagement policy, by which he allowed officers to continue in service, provided they accepted a reduction in rank from inspector or sergeant to constable. The appellant's case at trial and in the Court of Appeal was that this breached section 19 of the Bill of Rights, which is at page 470. Which provides that all decisions and acts of public officials must be lawful, rational, proportionate, and procedurally fair. The appellant's case was that was an irrational policy. The Court of Appeal agreed with the appellants, page 267. Paragraph 58 and 59. Paragraph 59 in particular, it was the very absence of the exercise of any judgment as to the qualities of the re-engaged and the needs of the force which led the judge to conclude the policy was irrational. And there was one exception which the Court of Appeal quite rightly ignored to find one exception does not in any way demonstrate in general the Commissioner did exercise any judgment. On the contrary, the Commission attempts to justify the rationality of the policy not to dispute its existence. So having found the policy was irrational, the Court of Appeal said that the appellants were not entitled to the remedy, and this is at paragraph 62, because it's not a freestanding point. The re-engagement policy, it said, cannot be considered separately from the mandatory retirement policy. It is a consequence of that. It has no effect subject to the mandatory retirement policy. It was designed merely to ameliorate its consequences, and no one could be subject to it. Over the page at 63, for that reason, if a non-gazetted officer is lawfully forced to retire, as I conclude, it would not be possible to consider amelioration of that situation as unfair or irrational. It puts officers in a better position. We have some difficulty with that analysis. Firstly, there was no obligation in law for the Commissioner to adopt an irrational policy. There was no obligation in law for the Commissioner to adopt a policy that only allowed officers to join the force, or sorry, be re-engaged rather, as constables, having been of a senior rank. He could quite easily, particularly after the law changed in 2010, carried out an assessment of the needs of the force and the individual officers on a case-by-case basis and said, well, we quite continue for you to continue in your place at a given rank, or you could quite easily have operated a policy where there was a presumption that people would continue in their rank unless the needs of the force or the individual performance suggested otherwise. The Court of Appeal described the retirement age of 55 as a policy. In fact, obviously it was the law. But just because, and in this scenario we make the assumption, just because the Court of Appeal held that that law was lawful, that it didn't breach the Bill of Rights, it doesn't mean that the policy to ameliorate the position cannot be irrational. I really can't say much more about our submissions. They're really as straightforward as that. And it's the fact that it was there to ameliorate, the fact that the officers would have been in a worse position if there'd been no policy, doesn't really answer the question that if you have a policy, you need to have a rational policy. Finally, I come, and somewhat ahead of time, I think, to the standing issue. We dealt with that in our case at paragraph 125 to 134. This concerns only the third and ninth appellants, and just to recap on the facts, 6 of my lay client officers accepted demotion and were re-engaged. 2, faced with the re-engagement policy, we say, decided they'd rather not stay in the force as a constable and left. This point concerns those 2, and it concerns their challenge to the re-engagement policy. It doesn't arise on any of the standing issues. It only arises if I've lost on every point until now. So section 26 provides of the Bill of Rights, page 472, provides for standing. And it provides that any person may apply to the Grand Court to claim the government has breached or threatened to breach his rights and freedoms under the Bill of Rights. And the Grand Court shall determine such application fairly and within reasonable time. We say that applies as much to section 19 as it applies to the other provisions of the Bill of Rights. It has been said that these appellants were not subject to the re-engagement policy, and so therefore they have no standing to challenge it. In the case of the third appellant, it said she would not have been retained as a sergeant in any event due to performance concerns. However, the judge's findings on this give her some comfort. They're at page 230, paragraph 210. 209, 210. With reference to the third appellant's application for re-engagement after retirement in the post of sergeant, just pausing there, the third appellant says, I want to stay in the force, I want to stay in as a sergeant. she finds as a fact the commissioner was entitled to act according to the recommendations of her supervisors, and that led to him denying her request. Well, we say that's a little odd, given that there was a blanket policy that nobody could come into the force unless they were at the rank of constable. It didn't apply to be re-engaged. The judge makes the point that the third plaintiff may have a remedy as relates to the inconsistency between the content of her performance development reviews and the comments made by her supervisors. And that stems from the factual findings at page 171 first, page 171. Paragraph 37 to 44. I'll invite you to read those in due course, but to summarise the position, the third appellant applied to stay in the force as a sergeant. It was initially indicated by one of her supervisors that that was fine. And then lo and behold, and this is paragraph 43, the detective Chief Inspector Raymond Christian, her line manager, solidly supported her application to remain in the force at her current position. And then, lo and behold, having done so in a second memo, he withdrew his support. So that's the point the judge is making about the PDR. So we would, in relation to that point, say it's far from clear cut that the real reason lying behind this was the operation of this irrational policy. So coming back to this particular challenge, we say that the third appellant and the ninth appellant are entitled to challenge the policy. They were affected by it, and it dictated their decision making. If the policy had been you can stay in the force as a sergeant, or you have the opportunity, depending on performance or on needs of the force, to stay in as a sergeant, then they would have applied to do so, and the third appellant did apply to do so. In short, officers in the relevant cohort were required to retire at 55. Those officers had a choice. They could either accept retirement under a law which we say, and in fact was discriminatory, even if it wasn't a breach of the Bill of Rights, was in fact discriminatory because it was unjustified discrimination, or they could accept demotion and stay under the force under a re-engagement policy, which we say was irrational and inflexible. The inflexibility of the re-engagement policy was the reason those officers left the force, and they're entitled to challenge it. And we invite you to give a wide and broad meaning to the definition of standing and the entitlement of the appellants to bring claims within under the Bill of Rights. And we've set that out in our written case, and I don't think I need to take you to it. I finished the point by saying the third and ninth appellants were not disinterested bystanders. They were people whose rights under the Bill of Rights were breached when it came to the re-engagement policy, and that policy effectively determined whether or not they would stay in the force. My lords, my lady, those are my submissions, unless I can be of any further assistance.
Yes, I think Lord Stevens has a question.
Give me, my Lord Stevens.
Yeah. If I could just bring you back to 522, which is the Adami against Malta case,
Yes.
where Sir Nicholas Bratzer is in fact in a minority and expresses difficulty with how the majority say that the case falls within ambit. If you could turn to page 523, which I think is the crucial passage, where he says that it's about 6 lines down in 017, thus according to the constant case law of the court, the application of Article 14 does not only presuppose the violation or direct interference, but it does not even require that the discriminatory treatment of which complaint is made falls within the four corners of the individual rights guaranteed by the article. He then gives, as an example, positive modality. Is there any other example that is available? I'm sure that Sir Nicholas Bradser had something in mind, but is there anything else apart from positive modality?
My Lord, no, but the issue about whether, I mean, this is in a sense, I think.
Look, I do apologize. I'm not saying in this passage, but I was wondering whether you know of any other example apart from a positive modality. That is, where a state adopts something, goes further than the convention, and if it does so, then it is required, then it falls within ambit.
My Lord, our answer to that is that the approach that has been taken subsequent, and by citing Adami and various authorities, and I perhaps deal with this by way of reply, is that in fact there's no practical difference between the approach in a positive modality case where against a negative interference case where we have a disadvantage, as in this case, and that this approach of Sir Nicholas Bradser has been applied successfully. But to answer my Lord's question, I don't have to hand a specific authority, but we can trace that decision making through various authorities where it has been cited. Often I accept in positive modality cases, but also, and I think from recollection, my Lady Arden touched on this in Steinfeld, where by reference to the M case, where I think one can get hung up about the definitions, but one comes back to this core test of a more than tenuous link to the core of the article. And if one sticks to that, we say, actually, if you look at particularly our first submission and indeed our primary submission on immutable characteristic, when you're talking about identity, I mean, scope in a sense is a red herring for us. We deal with scope because it's raised by the respondents specifically as an issue. But actually, our case is you don't actually need to get into that in our primary argument because we're well within scope on the immutable characteristic point. There are so many cases, we say, that clearly identify interference. I hope I'm not sidestepping my Lord's question when I say this, but we say there are so many questions, so many cases relating to interference with personal identity that you're well within scope. You don't need to be worried about the outer edges of that position. We use that judgment to demonstrate that scope is wider than ambit, and we can see from the guide to the court, which I took you to earlier on in my submissions, that is the advertised approach of the court. That is the approach of the Strasbourg court, and that isn't distinguished between positive modality cases or negative interference cases. If I may, I'd like, if I may, just to reserve my position a little on that and see if there's anything I can dig out to come back by way of reply on that point.
Very briefly, I'm sorry and this is just me trying to orientate myself. Why not bring a claim that the legislation that introduced this measure was incompatible?
Well, sorry, I'm not sure I understand. The legislation.
Well, you say that the legislation created discrimination as between different cohorts of police officers, and why isn't it framed in an incompatibility sense?
Well, the case was in fact brought as an incompatibility case. If one goes back to the pleadings, it was said that the law which retained the retirement age of 55, so that was in fact the later law, the 2010 law, which retained the retirement age of 55, but made different arrangements for officers joining the force after that was how the case was put, that this is that law that is incompatible. So I think we did deal with it in that way, my lord. If one goes
And
back
so
to
what relief do you seek from the board?
well, in relation to the board, the relief we seek is a finding, because the law has now changed. So we seek no declaration of incompatibility because the law changed. We seek a finding that there has been a breach of Section 9 read with Section 16, and that the matter be remitted to the Grand Court for the determination of compensation.
Thank you very much indeed.
Very well. I don't think there are any other questions. So, Mr. Perry, rather sooner than we expected, we've reached the time for your submissions.
Thank you very much, my lord. May it please the board. Our essential submission is that the decision of the Court of Appeal is correct. The mandatory retirement age of 55 for non-gazetted officers is not a matter falling within the ambit of Section 9 of the Bill of Rights or Article 8 of the Convention, which is coextensive with it. The Court of Appeal properly applied the severity test identified in the recent decision of the Grand Chamber in Denisov as the threshold to the consideration of Article 8, including its scope for reasons I'll explain when we come to look at how the case law developed. And accordingly, there has been no unlawful discrimination on the grounds of age. Our general submission in relation to Denisov, just sort of making a general point at this stage, which is in the bundle at page 713, but I'm just going to make a general observation, if I may, at this stage. Our general submission in relation to the decision of the Grand Chamber in Denisov is that it intended to do two things. The first thing that it intended to do, or the Grand Chamber intended to do, was to provide greater clarity on the ambit of Article 8 in the context of employment-related disputes. That is because, as we will see, the case law got into a bit of a muddle as to at what point you looked at consequences or reasons and justification. And it's quite apparent from the analysis of the Grand Chamber that the question of ambit was brought forward for the court to consider at the admissibility stage, which is why the complaint was dismissed on Article 8 grounds on the basis that ratione materiae, it did not fall within Article 8 of the Convention. So the court was applying an admissibility ground, Article 35 of the Convention, to exclude it. So that was the first thing, greater clarity on the ambit of Article 8. The second thing that the court was trying to do in Denisov was to herald a more restrictive approach to Article 8 in this particular context. So it was clarity and also restrictive. That is apparent from the court's discussion of the minimum level of severity and its emphasis on the serious impact. The court was clearly conscious, and we can see this from a later dissenting judgment to which I'll refer the board, but the court was clearly conscious to keep Article 8 in this context within proper limits for fear that states would be subjected to the burden in every case of seeking to justify a dismissal or a loss of office. It is also significant, we submit, that since it was decided in 2018, Denisov has been applied in two decisions which support the respondent's case. So there are two decisions which support the respondent's case. The first, to which my learned friend has made reference, is the Hungarian judge's case, JB and Hungary, in the board's bundle at page 900. I'll just make a general submission in relation to it, if I may, and I'll come back to it later. But the board will recall that it concerned the lowering of the mandatory retirement age for judges in Hungary. It was decided very shortly after Denisov in December 2018. The significant point to note is that the court unequivocally declined to apply a suspect reasons-based approach to measures that were based on age. The court looked at the consequences of the impugned measure and found that Article 8 was not applicable. And again, as in Denisov, the complaint was dismissed as inadmissible under Article 35 of the Convention. The appellants properly and fairly point out that it was an Article 8 case and Article 14 had been considered in conjunction with Article 1 of Protocol 1. That is a fair point. However, the Article 8 case was communicated to the respondent government by the court, as we will see, by the court, because the court wanted to consider the implications in relation to Article 8 when it gave judgment. And the respondent's short submission is that, having communicated the case on Article 8, and because Article 14 was in play, it would be curious if the court had overlooked the possible implications of Article 8 when read together with Article 8. The point about these cases, both Denisov and JB, is that the negative effects which the impugned measures had did not cross into the applicant's private life in any relevant sense so as to bring Article 8 within scope of the court's consideration. The second decision, which is an important decision, is the Novakovic and Croatia case. Again, I'm going to make a general observation, if I may, and give the board the bundle reference. It's at page 1289. But the board will recall it concerned the dismissal of a teacher of Serbian ethnic origin for failing to use standard Croatian in class, and who was considered unable to adopt owing to his pre-retirement age of 55. And it was found that this did involve a violation of Article 8. There are 2 points to note in relation to this case. First, it's not really a case about age at all. It was a case with a very specific context, namely the post-war conditions in eastern Slovenia at the time of the applicant's dismissal. So that's the first significant point. It's really an ethnicity case. The second notable feature of the case is the dissent of the chamber president, the Polish judge, Judge Wojciech. And I will have something to say about his dissent in due course. But if I may just invite the board's attention to what he had to say, and it's at page 1304 of the electronic bundle, and it's paragraph 2 of his short dissent, and it really begins at page 1303, and if I may just begin we can see that it's the dissenting opinion who sat as the president, the judge who was sitting as the president. He makes reference to the Lithuanian judge's dissent in a previous Hungarian case, which had criticised the scope of Article 8 and the ambit of Article 8. And the Lithuanian judge had said that it was important to return Article 8 to its natural angle and not allow it to be turned into a sign of infinity, which he does. It doesn't appear in this text, but in the original, it has the infinity mark. Then he makes reference to Article 8 becoming very extensive, and then he makes reference to how the court in Denisov had addressed those concerns. So this is the point that he's making about Denisov. And he said that they decided to overrule tacitly but unequivocally some of its earlier judgments. I'll come to look at these because some of these were the cases as to whether you look at the impact of the consequences at the justification stage or at the admissibility stage. And he then made it clear that the point about Denisov was that it was intended to be more restrictive and better reasoning. And his complaint about this particular decision in Novakovic, my friend said it's an age-based case. We disagree, but the criticism of Judge Wojciech is that it appears to be less restrictive than was intended by Denisov, but it doesn't matter for the purposes of the respondent's argument in this case. I can put Novakovic to one side for the moment. I'll come on to make some further observations in relation to it shortly in a moment. But the point that we make is that on the basis of Denisov, if Article 8 is not applicable at all, ratione materiae, there is simply no scope for the application of Article 14, and that is why Denisov is so important in bringing forward the point at which the consideration of admissibility is considered. And I'll make good that when we come to look at how the case law developed. Denisov has made it clear, we respectfully submit, that this is a context in which judicial restraint is necessary for the reasons explained by Judge Wojciech. If the consequences are not serious, then there is no subject matter jurisdiction and Article 14 cannot apply. The steps in our argument, if I may just deal with this before the short adjournment, the steps in our argument are quite simple. First, in relation to Article 8, it does not confer a right to full protection of private life or family life against all interference or embarrassment in private life or family life. If it did, it would have an exorbitant reach and impose, in this context, unreasonable burdens on state authorities. Second, Article 8 does not provide a general right to protection against dismissal or loss of office. Third, the scope of Article 8 to any dismissal, redundancy, or loss of office case is determined by the Denisov severity test, which means that a significant threshold must be crossed before Article 8 applies and before there is any interference with the right to respect for private life which calls for justification under Article 8.2. And the facts of a dismissal, as the board has seen, may fall within the scope of Article 8 in one or other of two particular ways. First, if the dismissal is based on suspect reasons, which have a significant impact upon the core values protected by Article 8. The values recognised in Article 8, such as dignity or autonomy. For these purposes, age is not a suspect reason, it is simply different. The second way in which a dismissal case may fall within the scope of Article 8 is if the dismissal has resulted in serious adverse consequences and the serious consequences have a detrimental impact, again, on the interests and values protected by Article 8. So it's serious adverse consequences, and the serious consequences have a detrimental impact on the interests and values protected by Article 8. That is, interests and values, as Denisov identified, such as family life, personal relationships, and professional relationships, not some general complaint that it had some form of impact on a particular individual. The minimum level of severity is a vital and crucial part of the analysis of the Grand Chamber, because otherwise the burden of justification and the requirement of the court to look at every case would be too exacting. And so far as Article 14, Section 16 of the Bill of Rights is concerned, the application of Section 9 or Article 8 determines the issue of discrimination. No question of discrimination arises in this case. And with the board's leave, what I will do is go on to look at the appellant's cases in very brief form to the findings made by the trial judge. I will also, if I may, look at some of the authorities that have that led to the decision in Denisov to make good the general submissions that we've made, that there has been no constitutional violation in the applicant's cases. Lord, if that's an appropriate point, I can deal with some of the facts if you would like me to.
Thank you, Mr. Perry. You don't need the board's leave to proceed in that way, save that you may not do so until 2 o'clock.
Thank you very much, my lord. Thank you.
The court's adjourned.